First case this morning is the City of Hudson versus Yerkey. Each part about 15 minutes to present the argument. Council, how long would you like to reserve for rebuttal?
3 minutes, Your Honor.
3 minutes, very good. I will let you know when you get to a minute left in your time. If you are looking over to your left of the clock, please look at the top one. Obviously we can kind of go from there. And then council, same for you. I'll let you know about a minute left in your time. You're the middle one. We won't be using the bottom one at all, so please ignore that if that's your able. The arguments are being recorded, so when you come up, please introduce yourself. Please stay behind the podium and speak in a voice that you can be heard on the recording. In this case, if you are going to use the name of a child, minor, or victim, please make sure you, during your argument, you refer to them by initials or some other phrase such as a victim or child or minor. We're ready to brief and ready to proceed whenever you are.
Thank you, Your Honors. May it please the Court, Andrew Harris on behalf of Defendant Appellant John Yerkey. Mr. Yerkey sent 3 separate notices to the court and the prosecutor informing him where he was incarcerated and that he would like to have this case disposed of. He was not brought to trial within 180 days of any of those notices, and I would submit, therefore, that the trial court below erred in denying his motion to dismiss on speedy trial grounds. There are a couple of threshold issues that this case presents. Just very quickly, I want to make a point about mootness that I did not specifically raise in my brief, which is that, among other terms, Yerkey is required to obey all laws for 2 years as a condition of his sentence. Necessarily, he hasn't completed that term. So in addition to all the collateral consequences we've outlined in our reply brief, I would submit that the case isn't moved for that reason.
I'm curious, I mean, he as I understand, served the entire sentence at this point in time. That's correct, he served all the time and then paid the fine?
Correct. And
what would happen if he didn't obey the laws? I mean, the court wouldn't be able to reimpose the sentence. What would happen if he didn't?
Perhaps it's a theoretical reservation of sentence. Maybe it's void and moot, but if this court holds that it's a nullity, I would say that the case isn't moved for all of the collateral consequences.
And I understand that, but the point you brought up when I read it was trying to figure out what, if anything, was left for Mr. Yerkey to have to do if he didn't do what he was supposed to obey the laws over the next 2 years.
So at least by its express terms, being charged with some other instance of illegality would violate the terms of his sentence, and he necessarily can't fulfill that condition within the 2-year time frame.
Fair enough.
The next threshold issue is whether the fact that he pled guilty waives our ability to raise this argument. And I would submit that it doesn't, because as a matter of foreign vocal law, you waive non-jurisdictional issues by virtue of making a guilty plea. But the statute in question, the specific statutory speedy trial statute in question here, is by its express terms jurisdictional, and says that if you are not tried within the time frame prescribed, no court any longer has jurisdiction over the case. The complaint, indictment, or information is void, and the case has to be dismissed with prejudice. So
could we go to the actual plea hearing with the Rule 11? Was there anything mentioned there about the fact that he wanted to appeal the speedy trial?
No, so the plea colloquy does not mention his appellate rights.
Well, I know that, I mean, I understand that you mentioned that, but what I'm specifically looking for is, and I don't think either party raised this, so it's probably not an issue, but I want to make sure, because there is a line of cases that we have in our court that if the defendant or the appellant, if it was discussed in court on the record that, that they wanted to appeal something, like their speedy trial, then it was not a knowing, intelligent, voluntary plea if they pled guilty.
So that doesn't appear in the record in this case. I would concede that.
Thank you. That's what I need to know.
That said, given the statute's invocation again of not just the word jurisdiction but also the word void, I think very well we might be talking about subject matter jurisdiction here, which is never waivable. And even if we are talking about jurisdiction over the particular case, and so maybe this issue would be waivable or forfeitable in some sense, but not by virtue of the guilty plea he gave. That the fact that he filed the motion below to dismiss is sufficiently preservative for the purposes of appellate review. Okay, so reaching whether he complied with the terms of the statute, whether he sufficiently invoked 2941.401 to make the deadline apply. I would submit that all 3 of his notices do that because they were substantially compliant. Now, this court has previously rejected the substantial compliance doctrine, and I guess first I just want to rhetorically push back. We've used those we've used those categories, those words, just because that's the way this court and other courts of appeals have described them, but I do at least want to rhetorically push back on the idea that substantial compliance is somehow unmoored from the statute's text. I think there's, in a sense, it better effectuates the text of the statute because in order to invoke the 180-day deadline provided for in the statute, a defendant has to cause the prosecutor and the court to get two things: notice of where they're incarcerated, and that they want their case disposed of. And to be sure, there are lots of other shall clauses in the statute that you shall forward a packet of information to the warden of the institution and so forth, but none of those contemplate the 180-day trial deadline being contingent upon their performance. As we've outlined in our brief, I think that better effectuates the logic of the Supreme Court's Tyler Williams decision, which presents an inverse situation where a defendant provides everything they have to provide to the warden, and then the warden sits on it, or otherwise the state's attorney and the court never become aware that the defendant did that. So in that situation, the Supreme Court says the failure of the state writ large to take action to bring the person to trial within the time frame prescribed inures to the detriment of the state. I submit that applies with stronger force here, because here we don't have an unknowing state's attorney.
Back in June, when he was sending stuff when he was incarcerated in a county jail, the state wasn't asked to act. They didn't have to do anything. They didn't send anything to him. They didn't delay and protect his right. The question just would be, when he did the county jail, would he have the ability to avail himself of 2941, 401?
So I think the answer is yes. I mean, the statute uses the language, a correctional institution of this state. It doesn't specifically define that as limited to DRC facilities. That said, even if you were to take that view, I submit that his third notice, which was sent from the Lane County Correctional Institution, does strictly comply with the terms of the statute.
In June, was he incarcerated pending trial, or had he been convicted and was serving time?
In June of...
When he sent his first notice in June, saying, I'm in the Mahoney County Jail, I think is where he was he incarcerated, or was he there pending charges from Mahoney County?
I would have to check the record. My understanding is that he was serving time, that he had pled guilty of the Mahoney County offense at that point. But again, you should check my recollection against the record. Again, 2941-401, it's a penal statute, it's a speedy trial statute. It's, as a matter of statutory construction, construed strictly against the state. As to that first notice, it says, it provides, at least in a bare bones way, notice of where he is, that he wants his case disposed of. He explicitly says, I am not waiving time. 180 days after the prosecutor acknowledged receipt of that document would have been December 11th of 23. It wasn't brought to trial within that point, and I submit that for that reason, what he did was sufficient to invoke the statute. And the court should have dismissed the action. Similarly, the second notice, while it wasn't the standardized DRC packet, it provided more information about where he was, how long he had been there. So I submit that both of those notices substantially comply. I think the case with the second notice is a bit stronger because it is a little more, I guess, expository about some of the details of the term of his incarceration at the Mahoney County Jail. And the third is the standardized DRC packet that he forwarded to the warden forwarded to the court and the prosecutor. The third notice presents a tolling question. I submit that it didn't toll time. That his
that third one was sent roughly October 25th. Is that the one you're referring to?
Yes, it was. So it was docketed October 23rd, and the prosecutor acknowledged in a handwritten filing receipt of it the same day that it was docketed. It was sent, I believe, the 16th of October. But even treating that 23rd date as the operative one, 180 days would have been up shortly before his arraignment in April.
He filed his own motion on the docket in January?
In January 12th. Now, so if this court holds that tolls, then I would concede with that assumption that the third notice wasn't, he was not, his speedy trial rights weren't violated. If that motion tolls, I submit that it doesn't toll. One, because the prosecutor did kind of immediately acknowledge receipt of it and say, well, look, he hasn't been served with a complaint. And it's clear that the court didn't intend to take any action on the motion at that point. Setting that aside, maybe the more important issue is all the cases that say filing of motions toll speedy trial rights are grounded in the text of the ordinary speedy trial statute. That is, a motion tolls time for speedy trial purposes because Revised Code 2945.72E says so. Here, the cases also make clear that when you are an incarcerated person subject to 2941.401, the notice of availability procedure, you are in, .401 land, for lack of a better way of putting it. And those provisions apply to the exclusion of Chapter 2945. So it has a different test for what tolls, what continuances can be granted. Specifically, it says the court can grant any reasonable or necessary continuance. And so maybe a broader scope of events can continue a case, but only for good cause shown in open court with the prisoner or prisoner's counsel present. And no such continuance happened here before the expiry of 180 days. So I would submit for that reason, the pro se motion can't toll under this specific speedy trial statute. If there are questions at this point, I'm happy to address them. Otherwise, I would just reserve.
We have about 4 minutes left. We'll leave the question. We'll work through that.
Thank you, Your Honors.
You can.
Request a box to stand up. Good morning, Your Honors. May it please the court, my name is Sarah Finelli. I'm the counsel for the city of Hudson. Actually, in this case, I'm also the prosecutor in the city of Hudson and handled this case at the trial court. We spent all of appellant's argument so far talking about whether or not the motion to dismiss should have been granted. When I think really the main issue here is whether or not this fellow should have been allowed to withdraw his plea in the first place. Because we don't get to that, we don't get to the other issue. But, quickly, even assuming that the January 12th, 24 notice was substantial compliance, even assuming that, the state still had plenty of time within which to try this individual. So whether it tolls or doesn't toll really doesn't matter in this case. In fact, the court had trial scheduled for May 14th, well within the 180 days. That wasn't going to be an issue. This man was in prison. He had a release date. We all knew when that was going to be, and we could get that ball rolling pretty easily. And we did. Okay. So the statute is full of shalls. The Supreme Court has said, shall means shall. You shall do that. And as prosecutors, you look at what a defendant sends you, and you have to determine whether or not it complies with the statute. The first item from this appellant was a letter. It wasn't even close. And that was the response that was given. The second one, it was confusing because the docket wasn't clear. It's still not clear in this case. There were some documents, but a reference to a letter that didn't make the docket.
And those are roughly June of 25, and again, there's nothing from anyone through the warden or anyone else with those first documents saying the person's incarcerated in this location.
Correct. The first is a letter when he's still in Mahoning County. Then because of the felony conviction that happens after the assault conviction, he is transferred into the state prison system. The one notice that we got indicated both that he was in the Belmont County Correctional Facility and in Lorraine. And the law is pretty clear. We don't have to go chasing and finding out where he is.
Well, it's not really chasing, is it?
It is, though. I mean, you have to figure out where
I
he is.
can look it up right here.
Well, yeah, you didn't.
True.
I don't know if there's anything in the record to tell us that the city did anything to find him in either Belmont or Lorraine at that time when you got the notice in October.
I think that's correct. But suffice it to say, the notice said both, okay? It does not comply with the statute, not even substantially, certainly not strictly.
But that is through the action of the state. This isn't something that Mr. Yerkey filled out. The state filled these forms out and seemed to give you contradictory information. Why should that error by the state harm Mr. Yerkey?
I don't think the record reflects who fills that out exactly. There's some portion of that form that's filled out by the appellant or the defendant as well. So he starts the process. He's got the obligation under the statute to get it to the warden, get the document started. There's no question the warden could make a mistake, but we don't necessarily know that in this case. Either way, we didn't have the right information. We didn't have what is required under the statute, and the state was well within its rights to not act upon what he filed.
I think the appellant mentioned in their briefs that we have not looked at Williams yet. We have not had a decision on this case since the Williams decision in the Ohio Supreme Court. Is that true? Or
I don't.
can you expound
I
on that?
can't at this moment tell you
Okay.
that. I
All right.
don't know the answer to that, but
Obviously, we'll find out, but I'm just wondering.
But certainly, you know, the law as it was set and as we acted upon what we followed. What the statute says, what the cases say, and that's how the state proceeded here, as you can see by the record.
It seems though that Williams has, seems like it's more of an evolving type thing. It's not as strict as, and I don't mean as strict like that, but strict as it used to be in regard to what the inmate had to provide to the prosecutor. So,
While that may be, and while the statute may even be arguably antiquated, because you're right, you can turn on your computer and find out exactly where somebody is. But the statute doesn't reflect that. And maybe it does need to be amended, but that's the legislature's job to do. And until they do, we follow the law that we have in front of us and handle these notices that we get according to the cases that we have and decided.
And
Relative,
this notice we're referring to comes in sometime in October.
I'm sorry,
The notice we're referring to now, that something from the warden came in October.
I believe that's correct. I believe that's correct. But it wasn't right.
I understand that,
Yeah,
but at
wasn't-
least,
wasn't
well, we're
right.
just getting the date, we're
Yes.
throwing out dates and there's this and that. I want to make sure we're all on the
I
same
think
page.
that's right. But the notice in January certainly then tells us exactly where he is and exactly what he's doing. Okay, at that point, we know. And he's filed a motion to dismiss. Now, whether or not it tolls, again, I said, it doesn't really matter because we still have 180 days to try this individual. And easily that could have been done here. But he chose to plead guilty, okay? And one item that has not been talked about by the appellant at all is the fact that his plea was counseled by a member of Mr. Harris's office. He had plenty of time to talk to him. He was transported. The record reflects even the period of time that he had. He was transported once for a pretrial. He decided to file a motion to dismiss. He replied. That was denied. He was back in court for a pretrial. The case was set for trial 2 weeks later. And then after an hour and a half of consultation with his lawyer, he came out and decided to plead guilty. And to your point, Your Honor, there was no discussion about appealing. The whole point of the plea bargain in this case was to get this matter over with for the appellant and for the victim. Do not forget, there is a victim here. This man was convicted of assaulting her, and then between the time of the conviction and the time of his sentencing, he menaces her by threatening to kill her in writing. So let's not lose track of that, okay? He was well counseled, waived his rights as he was required to do. There was no question about an appeal. And in fact, our plea agreement, and it's clearly in the record, was based on the fact that he would not be given any more jail time. That after more than a year, I think it was almost a year and a half, he had spent between the Mahoney County Jail and the prison system, he was going to get out. With the victim's approval, with the state's approval. None of that contemplated him turning around and appealing that conviction. And under the guilty plea, he can't. He just simply can't. The law does not allow it. The other thing we have to remember here is the court never would have had to accept a no contest plea in the first place. And the state would have. In exchange for his admission of guilt. We didn't ask that he be continued in jail. He, and the record is very clear, between his lawyer and himself talking about how he had substance abuse problems during this time, how his life had spiraled out of control. This man was a respected chiropractor, okay, who did a bunch of bad things that landed him both in jail and then in prison, okay, for acts of violence towards women. He stood there and told us all how he had problems, substance abuse, all sorts of issues, and then after that time incarcerated, he decided it was time to clean up his life. So everybody was willing to give him that opportunity. Now, there is no reason this court should not find this matter to be moot. To your point, he completed his sentence. Obey all laws for 2 years, okay. That's not an affirmative sentence. And in
That's
case,
not what?
it's not an affirmative part of a sentence. Could somebody...
Couldn't the court find him contempt if he, of that, obey all laws for 2 years?
Could, only if it's brought to his attention, only, but, it happens. It could happen, certainly. But that's not part of his sentence. It's not, he was fined, he had a term of probation, he completed that term. And the other important thing to remember is, appeals were filed here. It took a while to get it right, but during all that time, never was a stay filed. And it could have been. And he wouldn't have ended but he voluntarily completed his sentence. In misdemeanor cases, that renders this case moot, this appeal moot. The defendant was not allowed to withdraw his plea, nor should he have been. He was pled guilty on April 30th. He's brought back 2 weeks later for sentencing, after a PSI is completed and we're all satisfied that he's eligible to go out in the world and start his life over again. Never during any of that month's time is any question raised about his appellate rights, about the fact that he doesn't want to enter a guilty plea. It was part of the plea agreement. So 2 weeks go by, he's sentenced. 2 more weeks go by before we get a motion to withdraw. At that point, the law is really clear. In order to withdraw your plea after you've been sentenced to avoid the whole buyer's remorse issue, there has to be some manifest injustice. The motion doesn't even articulate one. It was a counsel plea. His sentencing was counsel. You would expect that if there was some misunderstanding on his part, remember, a week or 10 days before he was first brought to the Stowe Municipal Court to answer to this charge, he was resentenced in Mahoning County Municipal Court on the assault case. He appealed that case. The conviction was upheld, but he was brought back on a sentencing matter. He was returned to the court and sentenced just a week before this case got started and he first entered his plea. This was not unfamiliar territory to him. So one would think if he has a lawyer, he is asking his lawyer that question. So why don't we see an ineffective assistance of counsel claim? That's what you'd expect. Does his lawyer not tell him something? We don't know, because there's no complaint about that. Based on the law, and as we presented, we believe that this conviction should be upheld and the appeal denied. Thank you.
So I think it's fair to characterize the assignment of error related to the withdrawal of a guilty plea as a belts and suspenders argument. I mean, by its very terms, we've suggested that what we are trying to do is just provide another avenue by which this court can reach the merits of the speedy trial claim. To the point, why haven't we specifically articulated this as an ineffectiveness argument? I think, the hallmark of good appellate advocacy is raising your better issues and leaving, your perhaps less good issues on the floor. And I think there are probably Strickland prong one problems with an ineffectiveness argument, given, the fact that I think the better basis on which to reach the merits of the issue is that a guilty plea doesn't actually waive the specific genre of speedy trial claim at issue here.
Well, how could you have raised it ineffective assistance anyway? Because none of this is on record. You both agreed
Another problem with an ineffectiveness
If you
argument.
could really raise an ineffective assistance, we wouldn't have been able to look at it anyway.
That's correct, at least, in the posture of a direct appeal. To speak again to the mootness issue, Obeo law's 2 years, if it is not an aspect of the sentence, as opposing counsel suggested, but it is a basis on which the municipal court could initiate contempt proceedings, then even if it's not an aspect of the sentence, it is at the very least by itself a collateral consequence he faces by virtue of this case. So I think, however you regard that term, it poses, at the very least, reasons why this appeal is not moot.
What did you assert at the trial court level when you said we'd like to withdraw the plea? What did you say the collateral consequences were? Well, that wouldn't come up until the court now. At the time of the hearing, he hadn't completed all his sentence.
Correct.
And that's occurred to them. You allege in your brief there's collateral consequences for him.
Right. And maybe the best collateral consequence, the most direct collateral consequence, this is something that is in the record, at least to a certain extent, at the sentencing hearing. He has been a licensed chiropractor. He expresses a wish to become a licensed chiropractor. Again, at least in response to the mootness issue, I think this court has said you can supplement the record with the materials demonstrating that he has a disciplinary history, and we've cited law, statutory and regulatory, indicating that this sort of conviction is the kind of thing that would affect his attempts to restore his license. That, in addition to the Obeo law's 2 years term, is, if Obeo laws is not, like I said, part of the sentence, then it's a collateral consequence. Again, the essence of the Tyler Williams, to one of your questions, Judge Carr, is that it is designed to allow defendants to prompt action on part of the state, and the state writ large, the executive. You have to inform some, executive officer where you are and that you want to have the case at bar tried. Interpreting it, and beyond that, the Supreme Court characterizes as hyper-technical. So I would submit that Yerkey did that here with respect to all his notices, certainly respect to the third one, regardless of any ambiguity in the face of those documents about where he is. I think he has done enough there to spur action on the part of the state. The state, in its own responsive pleadings below, didn't make the case that it was unclear where he was at the time he filed that third notice. And I would submit that that's not a reason to regard that third notice as somehow insufficient to invoke the terms of the statute. And unless there are questions, I would ask this court to reverse and remand with instructions to grant the motion to dismiss.
Seeing no question, the court will take the matter under advisement and issue a decision in due course. When that decision is rendered, it will be mailed to you by the clerk of court and also be available on the High Supreme Court website. With that, on behalf of the court, I'd like to thank both of you for the presentation this morning.
Thank you.
Thank you.